Hey, greetings. Here doing a quick update. We've been getting calls from folks who watch our YouTube videos. So the gist of what I started doing my first video was trying to help people with federal court appeals with Social Security. Because basically, sometimes they represented themselves and they would lose, and then I was trying to tell them once you lose your hearing, where basically it's called an administrative law judge hearing, you go in front of the law judge and they ask you questions and there's back and forth with the judge and maybe a vocational expert. The court reporter's there typing away, and in the end you get an unfavorable decision usually about 60 days after you go to this hearing, and it's much like in this room here. So what we've decided is I call it the sweet spot. So everybody knows what I'm trying to focus in on is you get this decision in maybe 30 pages about the judge looking at the factors of what your severe illnesses are, what your ability to do in terms of level of function, light, medium, heavy. Each of those have categories with weight requirements, and they look at your past relevant work, and then they make a decision whether they think you can do work, whether it's past relevant work, or any work if you're under 55 years of age. And so we've been talking about 55 years of age people. It's easier to make a video about that, is that it's easier to win potentially at 55 because you only have to show you can't do your old job. So I just got a call from somebody, and they've always done, I forget what it was, same job, maintenance, for example. Never done it. So that's the job we have to get rid of, which is their condition now, mental and physical. They cannot do full-time maintenance. Maybe it's too much lifting, maybe their back, or they have some kind of physical problem that's in the spine that interferes with their ability to walk or their ability to lift heavy items. And to do their job, they have to do these aspects. So you have a hearing. You talk to the judge. You think you're going to win. You filed some of your records. You don't really know, but you think everything's been sent in. And then all of a sudden you get the unfavorable decision from the Social Security Administration Office of Hearings and Appeals is what it used to be called. Now it's Office of Hearing and Adjudication, I think. And basically that's when I'm asking people to call me. You didn't have a lawyer, you weren't fully prepared, you lost, and now you have an opportunity to go back to your doctor and say, look, the judge wasn't convinced because you didn't have enough detail in your records. Would you put the detail? Would you do the test, for example? Would you send me out to an MRI to show that the disc is actually pushing on the nerve? And then that doctor, within 60 days, you can ask for an extension, but if 60 days you see the doctor, they write a letter saying the spine has a disc that's pressing on the nerve. We didn't do it, and the judge said the MRI that was done 5 years ago didn't look that bad, and I just never got around, you, the person, to getting a new MRI, and you lost at the hearing, and the judge is saying if I would have had an MRI, you might have won. So now, sweet spot. You go to the Appeals Council, which is part of the Social Security Administration. You're not at federal court yet. You're at the Appeals Council level in Falls Church, Virginia. And so you basically say, we'll call him Dr. Smith. Dr. Smith sees you after the hearing. Dr. Smith sends you to an MRI after the hearing. You get the CD and the report. Goes back to Dr. Smith. And Dr. Smith reads the report and says, wow, that disc is really all the way over on your spine, the side of your spine, pushing on the nerves that are going down your leg, which is why your leg is weak, why you can't walk, why you have pain. That 5 years ago wasn't on the report, and now it is, but you went to the hearing without it. So now you're in the sweet spot. So you get the MRI, the report, and the doctor's letter, and you send it into Falls Church and say, hey, my doctor addressed what was in the judge's opinion about not being convinced. I've got new information that describes what was going on before the hearing. And that new information is material, which means it's a pretty big deal. An MRI, it's objective. And it's showing that my leg is hurting for good reasons. And it's on the films. You can see it, you can point to it. And the report says it's pressing on the nerve. And then Appeals Council has to review the whole file, not only what happened at the hearing, the records that were filed before the hearing, now the new evidence. That's the sweet spot. And so I'm saying when you call me, I run around and help you get this new information, usually from your treating physicians. It's the best. And then referring back to before the case was heard by the hearing judge about a condition that's always been there, it just wasn't documented. And sometimes they say, what's the excuse? Well, if the doctor that loves you and treated you never ordered an MRI, they can't blame you for that. So now you go back to the judge and you say, look, the doctor reordered the films, and more recent, they're only a couple months after the hearing, and they're showing something that's very significant. And the appeals counsel is supposed to either give you the benefits and you win, or give a good reason why that new MRI wasn't that big of a deal and it wouldn't have changed the mind of the judge, is the kind of basic way to say that. So, but the bottom line is, I've had cases after cases I can share with you where the federal judge, if the appeals counsel doesn't remand it back for a new hearing,